the submissions advanced by both the parties on the question as to which is the relevant constitution for the purpose of determination of the preliminary issue, I have come to the following conclusion. A. As per the Honorable Apex Court, if both the factions have submitted different versions of the constitution of the party, then in that case, what has to be taken into account is the constitution which was submitted to the ECI with the consent of both parties before the rival factions emerged. Before recording further conclusions, I find it imperative to reiterate that, pursuant to the initiation of these disqualifications, the Maharashtra Legislature Secretariat had vide letter dated 7 June 2023 requested the Office of the Election Commission of India to provide a copy of the party constitution / memorandum / rules and regulations on the record of Election Commission of India. Further, with respect to amendments, if any, to the said constitution of the party, the Election Commission requested the Legislature Secretariat to refer to the order dated 17 February 2023 passed by the ECI in dispute case number 1 of 2022. Having perused the same, it has to be noted that the copy of the constitution of Shivsena provided by the ECI does not bear any date or year, but as per the ECI, that which is provided vide the reply is the only constitution of Shivsena available on the record of the ECI. Further, with respect to the amendments, if any, to the said constitution, the Election Commission, vide its order dated 17 February 2023, has held in paragraph 132 4b that the amended constitution of 2018 is not on the record of the Commission. Thus, the petitioner's submission that the Constitution of the year 2018 has to be taken into account cannot be accepted, as I am bound to follow the directions of the Honorable Apex Court in Subhash Desai Supra, and accordingly take into account the Constitution which the Election Commission has provided. In my jurisdiction under the 10th schedule of the Constitution of India, I cannot delve into any other factor while deciding which is the relevant constitution. As prima facie, it is evident from the records of the ACI that the 1999 constitution is the one which was submitted to the ECI by the Shivsena before rival factions emerged. Further, it is also necessary to mention that the petitioner's submission that the constitution of the year 2018 was submitted to the ECI by referring to the letter dated 4th April 2018 cannot be accepted. A bare perusal of the said letter dated 4th April 2018, by way of which the petitioner based their claim of submission of the said constitution to the ECI, does not bear any content which shows that an amended constitution was submitted to the ECI. The said letter only refers to the election held and the results thereof, and nothing more. Further, on closer examination of the special leave petition filed by Mr. Uddhav Thackeray before the Honorable Supreme Court, challenging the ECI decision SLP number 3997 of 2022, I find that exactly same claim has been made about the letter dated 27/2/2018, and there is no mention about the new letter of 4th April 2018. Accordingly, said letter of 2/7/2018 is on the website of the Election Commission of India. However, there is no document relating to the constitution annexed to it. Hence, on this ground also, petitioner's submission that the constitution of the year 2018 has to be taken into account cannot be accepted. Petitioner's submission that submitted before the speaker, petitioner's submission that into inverted submitted before the speaker would mean into inverted annexed by the petitioner and the respondents in their respective petitions and replies thereto cannot be accepted, as there is a clear provision under the 1986 rule where the leader has to submit the party constitution. Rule 3, subclause 1, subclause B of 1986 rule mandates that the leader into inverted shall furnish into inverted a copy of the rules and regulations, whether known as such or as constitution or any other name of the political party concerned. Further, Rule 3 subclause 4 contemplates that whenever any change takes place in the information furnished by the leader of the legislature party under Rule 3 subclause 1, he shall as soon as may be thereafter, and in any case within 30 days from the date on which such change has taken place, or within such further period as the Speaker may for sufficient cause allow, furnish in writing information to the Speaker with respect to such change. Thus, the submission of Constitution before the Speaker has to mean submission under Rule 3 of 1986 rules. However, till date, Shivsena has not submitted any constitution on the record of the of the Speaker under the said Rule 3. In view of the above observations and finding, I need not further analyze any other submission in this regard made by the parties, and I hold that the Constitution of Shivsena provided by Election Commission of India, VDA, letter dated 22nd June 2023, is the relevant Constitution of Shivsena for determination of the preliminary issue as to which faction is the real political party. Constitution of Shivsena held to be the relevant constitution is hereinafter referred to as the SS Constitution. The leadership structure relevant for the determination. Learned Senior Advocate Mr. Kamat's submission that the leadership structure which is relevant for the purpose of deciding the preliminary issue is the leadership structure which is reflected in the communication dated 27 February 2018 and 4th April 2018 made to the Election Commission of India pursuant to the elections held on 23rd January 2018 is based on the petitioner's submission recorded in paragraph 89A to G herein above. Initially, the petitioner relied on the affidavit submitted to the ECI of the then office bearers of Shivsena, produced along with the affidavit in lieu of examination of chief to show that Shri Uddhav Thackeray had support of the majority in the organization. Respondents objected to such production on the ground that it is not permissible to produce affidavits of others along with petitioner's own affidavit in lieu of chief examination without the author of the said affidavits subjecting themselves to cross-examination. In any event, during the arguments, Mr. Kamat did not rely on these affidavits and limited his submissions to the 2018 leadership structure as available on the ECI website. Mr. Jethmalani, in turn, focused his submission to buttress the ground that the said leadership structure of 2018 cannot be considered and relied upon for the purpose of determining the preliminary issue, as the said leadership structure is not in conformity with the Constitution of Shivsena, which is on record of the ECI, and thus the same would be contrary to the findings of the Honorable Supreme Court in paragraph 168 of Subhash Desai. Mr. Jethmalani further relied on the legislative party leadership to submit that the legislative party also forms part of the leadership structure, as it is not only mentioned in the SS Constitution, but there is no dispute regarding the said members being part of the Pratinidhi Sabha under the SS Constitution. After having considered the submissions advanced by both the parties on the question as to which is the relevant leadership structure for the purpose of determination of the preliminary issue, I have come to the following conclusion. The submission of Mr. Kamath, the jurisdiction under the 10th schedule, only mandates a prima facie adjudication as to what the leadership structure of the political party was at the relevant time, and it does not extend to an inquiry as to whether or not the leadership structure available on the record of the ECI was pursuant to a validly held election is a correct position, and hence I concur with the same. Petitioner's submission that in these proceedings the respondents cannot challenge the organizational election results available on the record of the ECI, as the 10th schedule does not permit the raising of any such defense, is a correct position, and hence I am in agreement with the same. Respondent submission that the leadership structure of 2018 cannot be considered and relied upon for the purpose of determining the preliminary issue, as the said leadership structure is not in conformity with the constitution of Shivsena, which is on record of the ECI, does not arise at this juncture, as it is a submission which has to be considered while determining whether the said leadership structure can be relied upon for the purpose of determining which faction represents the real political party, which would be dealt with at the appropriate juncture. The only question which is to be determined in the current part of the order is what and who all constituted leadership structure of Shivsena at the relevant time. Respondents have led detailed evidence, and despite being confronted during cross-examinations, they have been able to demonstrate that no organizational elections were held on 23/1/2018. On the contrary, in the affidavit in lieu of examination of Chief of Shri Sunil Prabhu, PW1, has stated that organizational elections were held on 23/1/2013 and 23/1/2018. However, Shri Sunil Prabhu has not claimed any personal knowledge of the same or without and whether he was present during the said elections. During his cross-examination, he was confronted with the letter dated 28/1/2013. Thereafter, a specific question was posed to him by Mr. Jetmalani as to whether he voted in the said election, to which he responded in the affirmative. The contents of the said letter clearly stated that all the